So good afternoon, everyone. Good afternoon. I think we just ticked over to 12 there. My name's Solomon. I'm a lawyer at Darwin Community Legal Service. And today we'll be covering a monthly community legal education session on judgment debts and people on social security. So just a technical error. There we go. So I'd like to first begin by acknowledging the Larrakia people as the traditional custodians of the land we meet on today, and pay my respects to their elders, past, present, and emerging. Okay, so our topic today is, can judgment debts be enforced against someone on social security? The objectives of this presentation firstly is to just provide an overview of Australia's social security system, a brief overview, even though it is quite expansive and large. We'll just narrow it down to the key points. An overview of enforcement proceedings in the Northern Territory, and also an overview of how social security status or the receipt of a social security benefit, pension or payment can affect enforcement proceedings in the Northern Territory. Before we begin, we understand that people that are receiving social security payments may have various debts raised against them that may extend beyond things like a judgment debt. As that topic would be quite broad, we really are narrowing it down to instances and content where someone receiving Centrelink or a social security payment is being pursued by another party in a civil legal claim. In the case where there has been a court or tribunal order made finding that they're liable to pay a debt, and we're mainly looking at those enforcement proceedings, which is really, I guess, the final step in a legal matter. But I'll speak more to that as we progress. Just also note that Darwin Community Legal Service can provide advice and assistance in relation to most debt matters. So if you do have any clients that require free legal advice on a debt, whether it be a Centrelink debt, a judgment debt, consumer credit contract, feel free to refer them to us and we can see if it's something that we may assist with. So part one, social security. So essentially it's the system, it's a safety net that's been designed by government to provide for pensions, benefits and allowances. It's mainly governed under the Social Security Act that normally determines a person's eligibility for a payment and the rate of that payment. There are additional rules as well under the Social Security Administration Act, 1999, that provides an overlying governance function for the Social Security Act. Now, the main thing to take away in relation to judgment debts are that Social Security payments are absolutely inalienable. This means that they cannot be taken away, denied, or transferred to another person as long as the recipient remains eligible for the payment. And that's under the Social Security Administration Act 1999, Section 60. Obviously, the eligibility criteria for the Social Security payment will normally fall under the Social Security Act 1991. So you determine what payment someone's eligible for and the rate of that payment. And then there are additional rules about how the ultimate scheme is run in the Administration Act. But as long as someone qualifies under both those, I guess, tests, they essentially receive an inalienable payment. Social Security has a very complex history in Australia. So initially, it was more responsibility of state governments, with the Commonwealth government first moving into that, I guess, scene in 1908. Now, the reason for that was the Commonwealth was restricted under the Constitution, so they could really only make laws in relation to the pensions for the aging and persons with disabilities. That was under section 51, paragraph 23 of the Constitution. By 1944, the Commonwealth essentially was moving more into the field of providing a broader range of benefits and payments. So essentially there was now, in addition to pensions for persons with disabilities and the aging, they had pensions for widows, maternity benefits, unemployment benefits, and sickness benefits. Now, ultimately what happened was there was a challenge. It had to do with pharmaceutical benefits, and it found that it was unconstitutional for the Commonwealth to be making some of these laws for these payments. So in 1946, there was a referendum to increase the scope of section 51, paragraph 23. To insert a new power into the Constitution for the Commonwealth, so paragraph 23A. And essentially it expanded the scope of social security payments that the Commonwealth could make. So essentially the text is there. It empowers the Commonwealth to make laws relating to the provision of maternity allowances, widows' pensions, child endowment, unemployment, pharmaceutical, sickness and hospital benefits, medical and dental services, and benefits to students and family allowance. In the second reading speech for the current Social Security Act, then in the form of a bill, the Honourable Harry Jenkins, then Minister for Social Services, commented that the 1946 referendum confirmed the view held by Australians that Social Security was seen as a Commonwealth responsibility rather than the responsibility of the states or territories. And you can sort of see why you would have inconsistent benefits based on where someone lived, essentially, if it wasn't done by the Commonwealth. So someone in WA may be entitled to a payment that someone in Queensland wouldn't make. So after the referendum, the Commonwealth enacted the Social Security Act 1947. It was used to consolidate what was then 5 social security related statutes into one. Now Australia's consistently shown support for social security. So in 1972, Australia reaffirmed its commitment by signing the International Covenant of Economic, Social and Cultural Rights, whereby Article 9 stipulates the state parties to the present covenant recognise the right of everyone to social security, including social insurance, which is a concept that would cover things like the National Disability Insurance Scheme. The covenant was ratified in 1975. Now, we move to the present legislation. So essentially, the Commonwealth Parliament passed the Social Security Act 1991. Essentially, and the intent was to rewrite the Social Security Act 1947, so the previous law creating rights and benefits, to convert it into plain English. Now, if anyone has had the benefit of reading the Social Security Act 1991, I would say plain English is the last term you would use to describe it. It's probably the most complex legislative scheme that I've seen. And this has been observed by the judiciary. So in Justice Weinbergen, Secretary, Department of Family and Community Services in Greaves, stated, among other things, it is extraordinary to think that a bill drafted with such laudatory aims could end up as the Social Security Act in its present form. That was a comment made after it took senior counsel the better part of the morning just to work out whether someone who was clearly entitled to a payment, I believe it was carer's payment, was in fact entitled under the Acts when the facts of the case were very clear that they were, but they were just doing their due diligence going through the Act, trying to just make sure, confirm it. So social security payments, these are the sorts of things that a recipient receives under the Act, and it includes things like the age pension. So that's usually for people who have reached the age of 67 and are no longer working. There are some people that could access it younger, but it depends on your date of birth. The disability support pension, that's when you have a continuing inability to work. So you're getting a pension so that you have a source of income. A carer payment, so that's a payment where your caring responsibilities for another prevent you from working, so you essentially get income support to assist you. Parenting payment is the same as the carer payment, but in this case, you're parenting a young child rather than providing care to someone. Well, I mean, you are providing care, but not in the same sense, not as a carer. Youth allowance, so that's obviously for younger people to help them with support to basically pay everyday expenses. Oz study payments are for students, job seeker payments are for people that are currently unemployed and looking for work. And then special benefit is sort of like a catch-all, so it's in sort of extreme circumstances or special circumstances where someone is ineligible for any payment or any social security payment that's available, but they do need the money, and they meet certain residency requirements. So it's sort of like a catch-up fallback. Each payment has its own eligibility criteria. They provide a form of income support, and in certain circumstances, they could be subject to additional arrangements. An example of that's income management, when the government essentially Centrelink will quarantine part of the payment onto a basics card so that it can only be spent on certain things. So the case study for today, we've got Rudy. He receives social security payments because of a continuing inability to work due to a physical condition. Rudy resides in a caravan with his partner Anne. Anne receives social security payments to provide ongoing care to Rudy. Anne and Rudy jointly own/occupy the caravan. They have a motor vehicle registered in Rudy's name, which is used to transport Rudy to medical appointments to manage his physical condition. Rudy owes 6 grand to XY loans. XY loans have threatened legal action as payments have not been received for over 12 months. Rudy also owes a debt of $1,500 to another creditor proprietary limited. Anne and Rudy predominantly live paycheck to paycheck. Rudy has savings of $2,000 with the bank. That's the name of the entity as well. They may not be an authorized deposit taking institution. It's up to you to decide that. Now, if we just go through maybe we just break it down paragraph by paragraph. So we just start with paragraph 1. What's the likely payment that Rudy is receiving? It says a social security payment because of a continuing inability to work from a physical condition. Yeah, and feel free to use your mic or just answer in the chat. DSP, there we go, Tanya. So that's correct. Spot on there. So Rudy is likely receiving the disability support pension due to not being able to work because of a physical condition. Now, how about Anne? What sort of payment would Anne likely be getting? There, Teresa, perfect, spot on as well. Good work, all of you. So carer's payment is the one. Because Anne would be would struggle to maintain employment due to the Rudy's care needs and the fact that Anne has to provide that support. Now, in the event that there was, say, XY loans or another creditor start trying to commence legal action, what would be the real risks to the well-being of Rudy and Anne, just looking at the facts? I would say that the two main things are firstly the assets appear to be, there's 3 assets, $2,000 cash in the bank. There's a caravan that they jointly own, both of them. But it looks like Rudy's the only one that actually owes the money. Now, the issue there is the caravan isn't probably needed for them to live in. If you take that away, they'd be experiencing homelessness. And the other asset is the car, but it seems like the car is important, which will be relevant later, just because it's very clear that it's needed to attend medical appointments to manage his physical condition. So we'll move on to the next topic. So we've got enforcement proceedings. Now, the best way to think of enforcement proceedings is it's the final step in a legal matter. So as we look at this diagram here, you have the first step, which is when the cause of action arises. So there's a motor vehicle accident. Parties are obviously going to be in a dispute as to who's at fault. They can't resolve it directly between themselves, so they file in a court or a tribunal, and it goes through litigation. So they both present their case, and ultimately the outcome of the litigation should be that a decision is made as to who is liable and what's the amount that they're liable to pay. And that's when we get to the final step, which is enforcement proceedings. It's the final step, but it's also the step that probably is going to take the longest in terms of duration, because this is now the order has been made by the court or tribunal that person A owes person B money. Now person B has to enforce that order to try and get the money back. And whether or not they get the money back will depend on person A's circumstances. Or what are likely to get the money back. So enforcement proceedings, for the purposes of this presentation, we're going to be just focusing on enforcement proceedings in the local court of the Northern Territory. Now, all of it is governed under the Local Court Civil Procedure Act 1989 NT, so that's all under Part 5. And the main thing to look at would be Chapter 2 of the Local Court Civil Jurisdiction Rules 1998 NT. Because it sets out all the different mechanisms for enforcement and what's required, what steps need to be taken by a party to pursue that. So chapter 2 is usually the go-to section. So orders made by, say, the Northern Territory Civil and Administrative Tribunal, they would need to be, if I take a step back, there's two, in this example, there'd be two ways that you could pursue a claim. So the first one is the local court that can hear up to claims up to $250,000. But what's more common and what's more likely in Rudy's case is that it would be a small claim. That's any amount up to $25,000. And that's just based on the fact that the debts are for $6,000 and $1,500. Now, if you go through small claims through the Northern Territory Civil and Administrative Tribunal, the tribunal can't enforce their orders. So what would normally happen is the order is then registered in the local court, and then it may be enforced as though it was an order made by the local court. The final thing to note is that with enforcement proceedings, there's a 12-year limitation period. So if we go back, what we have is we got the cause of action arises. So it's step 1. At that stage, generally in the NT, it's 3 years to pursue a claim. So 3 years from the date of the accident. In other jurisdictions, it's generally 6 years, but in the NT, it's 3. Once you've gone through the litigation and the order's been made, it then becomes 12 years to enforce the order, because the substantive issue, which had a 3-year period to pursue and determine, is done. So it's now just more procedural and administrative at this stage once it gets to enforcement. Now, generally, local court orders for judgment debts or enforcement orders, they usually involve an order for payment of money, an order for delivery of goods, or an order for the possession of land. Today, we are just restricting our focus to orders for the payment of money. Now, just as well, just a bit more background. So Chapter 2 of the Local Court Civil Jurisdiction Rules 1998 characterise the parties to an enforcement proceeding as either a judgment creditor, so that's the person who the money is owed to, so the person who's entitled to enforce the order for the payment of money, and a judgment debtor, so that's the person who owes the money, so the person liable for an order for the payment of money. Now, generally, there's a few different ways that an order can be sought for the payment of money. Today, we're going to be focusing on the ones that are more likely to be affecting a person that is receiving Social Security. So the ones that the last 3 are very unlikely, because it's normally stuff like trying to seize shares that the person may hold, that sort of thing. So our focus is going to be on the warrant of seizure and sale, which is basically in order to get the bailiff to go to the person's premises and seize property to auction off. An attachment of earnings order, so that's if the person's earning wages, in order to garnish some of those wages, so redirect their income to the judgment creditor. An attachment of debts order, normally usually it's most likely used against a person's bank account. So it'll be an order directed to the bank to pay out some of the money that's in the judgment debtor's bank account to the court, who will then distribute it to the judgment creditor. And then the final one's the installment order, which is self-explanatory. It's really just an order that the person pays installments until the debt is paid off. Now, generally, the first step in enforcement is examination. Now, the reason for that is that in most cases, between two parties, they won't know each other's financial circumstances. So usually what will happen is there will be an examination of the judgment creditor will apply for a summons for a judgment debtor to attend examination. Now, what normally happens is they get served with the summons that lists the examination date, and they get served with a form, which is a declaration of financial circumstances form. The judgment debtor would then have time, a specified period of time, to fill out that form, where they would declare their income and expenses, as well as their assets and liabilities. And then they would attend the court for examination on the date listed on the summons. And it would be a chance for the judgment creditor to ask them questions to work out more information about the person's financial circumstances. As we can see here, we can assume that XY Loans has gone to, say, the Northern Territory Civil and Administrative Tribunal, they've made a small claim, they've succeeded, they've got an order for $6,000, which was the amount that was owing, and plus the costs of $200. So their cost of enforcing the process. And essentially it states that Rudy's been summoned to attend before the court to be orally examined as to his financial circumstances and his means and ability to satisfy the order made against him. And is requiring that Rudy produce the following documents to the court. So income statements from then to now from all previous employers and all Centrelink, statements from then to now for all accounts that Rudy controls or benefits from with a bank, basically, an authorised deposit-taking institution. And registration, they're also asking for registration certificates issued by the motor vehicle registry. Now, this would be most likely to ascertain who owns the vehicle. We go back to our case study. And what we can confirm is, although out there, yeah, it's registered in Rudy's name. Now, after an examination, the registrar may make an order for the payment that the circumstances require. So what essentially is appropriate in the circumstances. Now, if we go back to our case study, Rudy has been personally served with an examination summons. So that's the form 47B that we have here. And it's by one of the lenders, so it's XY Loans, following an NT-CAT order for payment being registered in the local court. So firstly, what should Rudy include? We go back. Yeah, so income statement, medical history is good as well. Car registration is good. It wouldn't necessarily need to include the medical history, but it is useful to have that because it does provide some. I guess it does help the registry know whether or not there is a capacity to pay and what the limitations may be on earning an income. We've got the car registration, we've got the bank statements. Now, the other things would be disclosing the caravan and making it clear that it's part ownership, so that it's a jointly owned asset. and making them aware of the vehicle and its value. The $2,000 at the bank should be disclosed as well. And then also their income, their level of income, but also Rudy's income, and also the fact that the income is through Social Security. What should Rudy also mention? So there was talk about the medical situation as well, other debts, Heather as well, very good point, because it's all relevant for the capacity to pay the money back. But yeah, essentially it is an opportunity for Rudy to be transparent and make sure that there's enough information so that they can make a decision. Now, Rudy has completed the statement of financial circumstances. Essentially, what it's including is gross weekly income of $339.50 from the disability support pension, total property and assets, so the caravan, $10,000, the motor vehicle, which is $2,500, and the deposit in the bank, which is $2,000. Rudy's outlined all of his expenses. And he's also outlined the other debt, so the $1,500 to another creditor proprietary limited, which is due in 3 months. Rudy has given Anne's name as the joint owner of the caravan, so just forget that it says unit there, that's an error. And Rudy has outlined his health conditions, which prevent him from undertaking employment and require routine checkups. So part 3, Social Security and enforcement proceedings. So just for everyone's benefit, we've covered Social Security, so the safety net that we have in Australia that ensures that there's income support for people who need it. We've covered the enforcement proceedings, so the process for someone to try and recover a debt from someone after it's been through a court or tribunal. Now we're going to cover where these two things meet. So the first enforcement order, the warrant of seizure and sale, this takes the form of a 44A. Essentially, it's an order to take possessions belonging to the judgment debtor and sell them to obtain the money owed. So this is, for example, a bailiff attending Rudy's caravan, going through, working out what belongs to Rudy, what's jointly owned, and what's not Rudy's, and of Rudy's things, the bailiff could then seize it and sell it. Now, there is an exemption to that, and that's where it's personal property that's necessary for adequate living and continuation of work. Now, where that could be relevant with Rudy is that he could raise the issue with his health conditions and the fact that the motor vehicle is needed to attend those medical appointments. Now, the final thing is that the object of such a warrant is to leave the debtor a minimum quantity of goods on which to live. So anything that's really considered a luxury or a non-necessity can be seized and sold. And just another thing, if the thing that's seized, they do expressly mention this in the rules, if the thing that's seized is cash, then they don't need to sell it, they just seize the cash. Because you wouldn't auction off cash because it would make sense on USD. Yeah. So the next one, attachment of earnings order. So this is an order, it takes the form of essentially the 48A and 48B in the rules. The orders made against the judgment debtor's wages, salary, or pension. Essentially what happens is the court will first consider net earnings, so they deduct taxation and superannuation, person's gross earnings, to determine an appropriate deduction, which is a reasonable deduction from the net earnings and is not more than is necessary to pay the judgment debt within a reasonable time. So those are the factors that are considered in determining an amount that's to be redirected from someone's wages. Now, under the local court rules, earnings does not include a pension under the Social Security Act or the Veterans Entitlements Act. So essentially the effect of that, just to be clear, is that it can't be made against someone's social security payment or pension. Attachment of debts order, so this is applied for through a form 49A. It's also known as the garnishee order. It's an order made to garnish money held by a judgment debtor in an authorised deposit-taking institution, investment fund, or corporation. So the simplest example is seeking an order against someone's bank account to take the money that's inside that bank account. Money must be due or accruing to the judgment debtor from the garnishee on the day of the judgment creditor's application. So it's focusing on a snapshot in time. It's on the day that the application was made, what was the balance in the bank account. A registrar may refuse to, so a registrar at the court may refuse to issue a garnishee summons or make an order if of the opinion that the order sought is worthless or vexatious because of the smallness of the amount to be recovered or the debt sought to be attached. So if someone's, say, making an order for $30 over someone's bank account, it's the expense in just doing that it's going to significantly outweigh the benefit of receiving that $30. So it would mean that the court would be very reluctant to make that sort of an order. Now, there is a direct intersection between the attachment of debts order and Social Security. And this comes back to the fact that Social Security payments are absolutely inalienable. However, some people might think when we go back to the attachment of earnings, so obviously you can't seek an order to attach the money coming out of Centrelink directly because this is where the inalienability becomes relevant. But what about when it's cash in the bank account after it's been paid? It leaves open the question, well, can you still do an attachment of debts? So say Rudy's got his $339. Sure, you can't seek the order against Centrelink to have them redirect that money to you. But once the money goes from Centrelink into Rudy's account at the bank proprietary limited, could you then seek an attachment of debts order over that money? The answer is it's complicated. So Section 62 of the Social Security Administration Act 1999 governs the application of an attachment of debts order on money paid under the Social Security system. So essentially Section 62 stipulates that if a person has an account with a financial institution, so Rudy with the bank, and either or both of the following subparagraphs apply. So installments of a Social Security payment payable to the person are being paid to the credit of the account, so a positive balance in the account, or an advance payment of the Social Security payment payable to the person has been paid to the credit of the account. And a court order in the nature of a garnishee order comes into force in respect of that account. The court order does not apply to the saved amount in the account. Now, the saved amount is a very technical thing, and we are going to cover it. But essentially, you need to calculate the saved amount. And the way you do that is you need to calculate the total amount of Social Security payments paid to the credit of that account during the 4-week period immediately before the garnishee order came into force. And then you need to subtract from that amount, so the summation of the Social Security payments paid to the credit of the account, you must subtract from that amount the total amount withdrawn from the account during that same 4-week period. Now, this is confusing, but I've got a worked example. So Rudy has $2,000 in his account with the bank. We know that. That's on the day that XY Loans application for the attachment of debts order is filed with the court. Now, if we look at the preceding 4 weeks, Rudy's transactions are as follows. So 4 weeks ago, Rudy got his weekly payment from his disability support pension of $339.50. So that's in that same week, he withdrew $239.50. 3 weeks ago, Rudy got his weekly payment, same amount, and he only withdrew $139.50. 2 weeks ago, he gets his gets his weekly payment again, and he's withdrawn all of it this time. And then 1 week ago, he gets his same weekly payment, but he doesn't withdraw anything. Now what we'll do is we'll work that out. So the total payments, we got $1,358 paid over that 4-week period. Total withdrawals, we've got $718.50. So now we need to withdraw, subtract the withdrawals from the payments. So we got the payments to the credit of the account is the $1,358. We subtract those withdrawals, the $718.50. And then we then get the saved amount, which is the remainder, which is $639.50. Now, again, the reason why this saved amount needs to be protected is because it's Centrelink money and it's absolutely inalienable. So the garnishee order can't be subjected, can't seize that saved amount. Now, we look at Rudy's bank account, there's $2,000 in there. We deduct the saved amount, which is the amount that's attributable to Social Security payments that were paid over the preceding 4-week period. So that's the $639.50. And it leaves us with a remaining amount of $1,360.50. So that amount can be seized under an attachment of debts order. However, the attachment of debts order can only apply to that amount. It cannot apply to the whole $2,000. It can only apply to that $1,360.50 that's remaining after you deduct the saved amount. Does that make sense? As confusing as it is.
So it's withdrawing from, so that's not into his, that's from. I'm not all over here actually.
Yeah.
Deposits.
It's confusing.
Assembly account like you Senate. So what about like Senate pay? Isn't that like a disbursement instruction? They said, right, it goes into here and then you go.
So a very good question has been raised in house. What if the person's receiving Senate pay? Well, the answer to that would be that it can't be subject to an attachment of debts order because with Senate pay, the money never goes into the bank account to begin with. It's directly paid by Centrelink to the third party recipient. The payments directly.
Professional lead role before moving.
So essentially with Senate pay, it wouldn't come up in this calculation because it wouldn't be subjected to the attachment of debts order to begin with.
Right.
But it's a very good question.
I'm just trying to pair it.
Yeah.
I thought it was an instruction, so actually say no, Senate pay this much. Obviously,
It depends on how the person wants to approach it in that case. Now with the installment order, so the way that's applied for is a Form 58. It's an order that's made on application to the court by either the judgment creditor or the judgment debtor. Now, when an application is filed for an installment order, the other party has 14 days to file an objection if they disagree with the proposed installment order. Now, the other option is that parties could enter into an installment agreement in the form of Form 50G and file that with the court. That would be, for example, if Rudy agreed with XY loans to pay, say, $50 a fortnight. They both just do it in that form, they file in the court, there it is. Now, the benefit of installment orders are that generally enforcement proceedings will cease and no interest will be payable on the judgment debt whilst the judgment debtor is compliant with the installment order. Now, interest is quite high on judgment debts. I think at the moment it's, not sure, it's about 8 to 10% post-judgment interest. It's quite high. And it's
9 or something.
Yeah, and the interest is really supposed to act as an incentive to pay the judgment debt, because if you don't pay it, the interest is just going to keep accruing on the debt. Now, the benefit of an installment order is that if a debtor enters into that order or an agreement and they comply with it, the interest generally, unless the court orders otherwise, the general rule is that the interest will stop accruing at that stage whilst it's being complied with. A party can apply for a cancellation or a variation of installment order by filing a Form 50B. So yeah, we've went through there, we've got the post-judgment interest rate currently 10.35%. Yeah, which is used here at the anti-local court. So that's the benefit, is that you having the instalment order will, unless the court orders otherwise, generally will stop that interest from accruing, that 10.35% as it currently stands, but it changes depending on what the cash rate is that the Reserve Bank sets. Now, again, parties can apply to vary or cancel an instalment order. That's for a Form 50B. Judgment creditors' applications for an instalment order must be supported by affidavits stating the facts upon which they rely. A judgment debtor's application must be supported by a declaration of financial circumstances. So a declaration as to their assets, liabilities, income, and expenses. And it needs to take the appropriate form. Now, one approach can be for a judgment debtor is that they could be proactive and file an application for an instalment order on terms that suit them. So a repayment arrangement that suits them, because the benefit is they would potentially get an instalment order that would be on payment terms that suit them. And the interest wouldn't accrue whilst they comply with it. And it would then be the onus would then shift on the judgment creditor to, if they had an objection, to file an objection. So either party can apply for an instalment order, and sometimes it could be prudent for a judgment debtor, so someone who owes money, to file an application to get an instalment order in place to prevent that accrual of interest. Now, generally, where a client is being pursued for a debt, whether a judgment debt or a letter of demand, the following steps may assist them. The first thing is that they should immediately seek legal advice. I would recommend that anyone does anything without first seeking legal advice. We're a free legal service that can assist, and it's why we exist, is to provide that legal advice and be accessible to people that are going through these sorts of situations. Other options could be anti-legal aid. If legal aid can't see the person, they could give the person a legal aid voucher, so they could get free legal advice from a private lawyer in the event that we couldn't see them. Nudge is another option as well. So the North Australian Aboriginal Justice Agency. But essentially you seek legal advice because there's a few ways of approaching it, and you don't want to approach it the wrong way. Now, you be proactive, so following legal advice, and depending on what that legal advice is, if this is consistent with the advice, it can pay to be proactive in some cases and negotiate a payment plan with the creditor before legal proceedings commence. That way, you could potentially a person could potentially avoid costs and interest from accruing. Or where a judgment creditor is being hostile, the individual, so the judgment debtor, could consider applying for an instalment order based on the amount they can afford to pay without experiencing further hardship. It would then shift the onus back onto the judgment creditor to challenge it if they don't think it's suitable. Now, another option is communicating with the court and the judgment creditor to see if direct resolution is possible. Generally, a judgment debtor should be transparent. So generally, if you're assisting a client that's going through this situation, you might want to assist them in making their financial circumstances clear. Generally, they need to, if they've received an examination summons, for example, so that's a summons for them to attend court and disclose their financial circumstances. The rule is that they do need to file that in the form of Form 47C at least 7 days before the examination. So assisting a client to complete that financial declaration of financial circumstances can be helpful because it at least informs the court and the other party on the client's capacity to pay a judgment debt. And the final thing and the key point is do not ignore any court summons or orders. This is, firstly, it's the client's opportunity for their circumstances to be considered during an enforcement proceeding. The second thing is that failure to attend an examination may result in the court issuing a warrant for the client's arrest. So those are two big risks of ignoring it. Generally, the first thing that everyone should do is seek legal advice immediately if they receive any sort of legal document or letter of demand. That way, at least they can get some advice on where they stand in relation to the situation. Some resources. So the forms are accessible on the local court website. If a form isn't on the local court website, the other option is that you can go to the schedules of the local court civil jurisdiction rules, and the forms will be there. Additionally, if you have any clients that are experiencing the situations that are outlined in this community legal education session, you're welcome to refer them to us. And finally, other options can include financial counselling services. So there's a list of referrals there. Generally, you've got people like Catholic Care and Anglicare that can assist. And the National Debt Hotline or Helpline, sorry, is always available as well. Heather, I see your hand is raised.
Hi, Solomon. Thank you very much for the presentation. I just wanted to jump in here and let everybody know that I'm a new recruit with ASIC. And ASIC is running a couple of investigations into credit providers working outside of the responsible lending guidelines. So if anybody does have clients who they feel have gone into loans that they can't service based on maybe some dodgy practices, we'd really like to hear from you. I'll drop the email address in the chat. There's a joint investigation going on with the ACCC about motor vehicle financing as well. So if anyone does need any support, and actually even just to help us capture a bit of a snapshot of that behaviour that's happening out in the community, that we'd be really grateful.
Yeah, that would be that's fantastic, and thank you for raising that, Heather. And I might reach out to you after this presentation because it is something that we do occasionally see.
Yeah, wonderful.
Yeah, but it is a concerning area. But yeah, yeah, I'm sure you could share your details. I might send. I'll reach out to you. Yeah.
Great, thank you. Fiona's already on it. Hi, Fiona.
And Danica, just the intake process for DCLS. What I'll do is when we send out these slides, I'll make sure that that's included on the email. Generally what will happen is the details will be sent to us just via email is fine. We have 2 email addresses, which I'll include when I send the slides out. But generally you would just send the client's details through. We would call the client after that to book the appointment and just make it clear if the intent is that it is going to be a joint call with the client. That way, when we contact the client to book the appointment, we'll ask them if they want a joint appointment, and then once the client's confirmed that, we would then book it in and reach out to you as well, and we'd have the joint appointment at that stage. So yeah, it's not a complex process. We try to make it as straightforward as possible. So thank you all for your attendance today and active participation. Now, are there any questions or suggestions? No, all clear. That concludes our presentation today. I'll end the recording, and other than that, I'll send through the slides, and you'll have my contact details as well if you want to ever have a chat about something in relation to any sort of usual matter that may arise. There you go. Bye everyone.